Hi, everyone. I'm Brianna Rucker, Diversity and Inclusion Committee Chair of the Beverly Hills Bar Association Barrister Section. And I'm delighted to introduce today's speakers, Beth Gellman-Beer and Amy Needlestilkowski. Beth Gellman-Beer is an experienced civil rights attorney who spent 18 years with the U.S. Department of Education's Office for Civil Rights, where she investigated and led high-profile cases involving discrimination and harassment under Title IX, Title VI, Section 504, and related statutes. She now co-leads Evergreen Education Solutions, a consulting firm that provides independent investigations, policy guidance, and training for schools. Mrs. Gellman-Beer also previously served as a subject matter expert on Title IX enforcement and compliance for multiple national educational initiatives. Amy Needlestilkowski is an education and civil rights attorney with over 2 decades of experience, including nearly 20 years at the Department of Education's Office for Civil Rights, where she served as chief regional attorney. There, she investigated and resolved hundreds of discrimination complaints and provided extensive training to schools and OCR staff nationwide. In 2025, she co-founded Evergreen Education Solutions, where she now offers independent investigations, policy consulting, and training for K-12 and post-secondary institutions. And now, without further ado, let's get started.
Hi, everyone. Thank you so much for joining us this afternoon for this CLE about the rights of students who have been subjected to shared ancestry harassment and the responsibility that schools have to those students. I'm going to use the term schools today, but when I'm using that term, it can mean a variety of different kinds of schools. So public K through 12 school districts, charter schools, post-secondary schools, whether it's a college, a university, a trade program, or anything along those lines. So we have a lot to cover today in just an hour, but I quickly just want to share with you what we are going to be talking about today. We'll start with an overview of Title VI, which is the law that prohibits discrimination on the basis of shared ancestry, including in areas such as Islamophobia and anti-Semitism. We're going to talk about the types of conduct that constitute shared ancestry discrimination and harassment, and how you and your staff can identify it, as well as the applicable legal standards when these kinds of incidents arise at schools. We'll cover how schools should respond to shared ancestry discrimination and harassment. And this is important for schools so they know how to respond. And it's also important for community members to have an understanding so they know the type of response they're entitled to if they should experience this type of conduct. We're going to share recent shared ancestry harassment cases with you in order to illustrate how Title VI works in real life examples. And we're also going to talk about the current legal and enforcement landscape, including options for pursuing claims of shared ancestry harassment. Next slide, please. Because Beth and I both come from the U.S. Department of Education Office for Civil Rights, we wanted to take a few minutes to talk about OCR because we'll refer to some OCR decisions during the CLE today, and also because OCR still plays a very important role in addressing shared ancestry discrimination and harassment in schools. So, the Office for Civil Rights is a federal law enforcement agency. It's responsible for enforcing Title IX, which prohibits discrimination on the basis of sex, Section 504 and Title II of the ADA, which prohibit discrimination on the basis of disability, as well as Title VI, the law that we're here to talk about today. Generally, OCR has jurisdiction over recipients of federal financial assistance from the U.S. Department of Education. So, public school districts, charter schools, colleges, universities, post-secondary programs, including even private colleges or universities, as long as they participate in federal financial aid. Generally, OCR is complaint driven, meaning an individual or an organization files a complaint, Or at times, OCR will be aware of something that's happening and it's out in the public, and on its own, it has the ability to open a directed investigation and decide on its own that an investigation is warranted. No matter how the complaint comes to OCR, assuming it has jurisdiction and it's going to move forward, it'll conduct an investigation. So it's going to interview witnesses, review relevant documents and data. It'll make a determination based on that investigation. And if it finds that a law has been violated, it'll enter into what's called a resolution agreement with the school. And then it monitors that school's implementation of the agreement until the school is back into compliance with the law. So, our focus today is schools, no matter what kind of school, it's on education. However, we do want to acknowledge that shared ancestry harassment takes place in a variety of settings. It certainly is not limited to schools, and there are laws in place, both federal, state, local laws, to address this type of conduct when it happens outside of schools. But today, our focus is going to be in the educational space. So that leads us to the question of why is it important for this training to take place today, especially now? In other words, why are we here? There's a variety of reasons. The first being that in the past 2 years or so, there's been a quantifiable increase in the number of shared ancestry discrimination and harassment cases. Although this is not a new problem, we've seen a real uptick in the number of incidents and cases and complaints. It's also important because of the harm that it can cause on a campus. So it's harmful to students, right? If a student is being harassed at school, they don't feel safe at school. They may have anxiety about going to school. We see things like decrease in their academic performance, decrease in attendance. So it's important to address from a student perspective, but it's also important to address for the school employees' perspectives. It's harmful to teachers, administrators, and staff. They also can be fearful of their workplace. We've seen in cases a decrease in employee morale or an increase in employee turnover, which isn't good for the stability of a school. And finally, it's an important topic to address because schools that don't take action to address incidents of shared ancestry and discrimination in a timely and appropriate manner, they can be subject to liability, whether it's through an OCR complaint, a lawsuit, or bad press and bad publicity, which is also not good for a school. So, our goal today is that everybody leaves today with an understanding of not just what shared ancestry harassment is, but also steps that schools can take to proactively address it to create a better environment for their students, their employees, and to decrease their liability. Next slide. Oh, so the title of our presentation today is Title VI Shared Ancestry Harassment. So the first thing we need to talk about is what is Title VI? So I mentioned briefly, it's a federal law that prohibits discrimination on the basis of race, color, and national origin by recipients of federal financial assistance from the U.S. Department of Education. You'll notice that nowhere in the statute or in the regulations enforcing Title VI does the term shared ancestry appear. However, courts as well as OCR have long interpreted Title VI prohibition of national origin discrimination to include shared ancestry, such as Islamophobia, anti-Semitism. It's important to pick out that there's a distinction, though, between this Title VI prohibition of shared ancestry discrimination and religious discrimination. Title VI does not prohibit discrimination on the basis of religion, though there are other state, federal, and local laws that do. Our focus today is on the shared ancestry component. So I think of religious discrimination, for example, if a student is not allowed to join a particular club at school because they're Catholic or Muslim or Jewish or whatever the religion may be. That would be something that falls squarely within a religious discrimination context. So what we're talking about today isn't that. It's something that's slightly different, and we'll spend some time defining and giving examples of what we mean by shared ancestry discrimination. Next slide, please. All right, so when we're talking about shared ancestry discrimination, on the screen there's a list of examples. I'm going to break some of them apart for us today when we're talking about it. So the first one we have is citizenship in a country with a dominant religion or distinct religious identity, or someone who's perceived to be of a particular citizenship or national origin. So this includes things like making stereotypical assumptions about somebody based on where they're from, or saying derogatory things about a person who's from Israel or majority Muslim Middle Eastern country based on stereotypes or just based on that geographic or ethnic origin that they may have. Second on our list are racial, ethnic, or ancestral slurs or stereotypes. I don't want to give any specific examples of those. I think we all know what I mean by that, but we see this type of behavior come up quite frequently when we're talking about shared ancestry. Another one, third on our list, is how a person looks. So things like their skin color, their physical features, their style of dress, if it reflects their ethnic and religious tradition. And this one can be sometimes very clear, but at other times it can be a little bit confusing for schools to address because the context really matters. So the behavior matters, but as does the context. So I'm going to use my own child as an example. My son recently got what I consider to be a ridiculous haircut called a modern mullet, where it's kind of bushy on the top, a little bit longer in back, and sort of shaved on the sides. He did that, and he's in high school, and friends of his, kind of joking, but they made fun of him for his haircut, which I completely understand. I can see where, in a different context, if it hadn't been joking, that could have turned into maybe an incident of inappropriate behavior at school, some sort of bullying or something along those lines, which in the context for what happened to him, it was not. But I can see where that would have happened. There's clearly no shared ancestry component to that. It was just a bad haircut. Now, if you have a student who's Sikh, who does not cut their hair, who may wear a turban over their hair, if they are made fun of because of their hair, if they are made fun of because of their head covering, that veers into shared ancestry harassment. And we can see where, yes, both of those incidents pertain to a student and it pertains to their hair and how they wear their hair, how much hair they have, those sorts of things. But when you look at the underlying context, we end up with two very different situations. Like I said, the situation about my own kid, that might fall somewhere under a school's code of conduct and some disciplinary action there. But there's nothing that would implicate Title VI or a school's responsibilities under Title VI. As opposed to the second example, because of its tie-in to that student's ancestry or ethnic characteristics, that very well may invoke a school's Title VI responsibilities. Another way that shared ancestry discrimination and harassment can come up are students who may speak with a foreign accent or have a name that is not a typical American name that they're being made fun of for, maybe names that are commonly associated with a particular shared ancestry or ethnic characteristic. It can also come up if students are speaking a foreign language at school. Maybe you have a population of students who share the same ancestry, and when they're together, they will speak in a different language other than English. If they are being picked on, made fun of, harassed for that, you may have a Title VI shared ancestry situation that you need to address. And we are going to talk in a few minutes about how to determine if something needs to be addressed under Title VI. But right now, I just want you to keep these sort of general categories in mind. And we spend a lot of time talking about these examples and how shared ancestry comes up in schools because often it's going to fall to staff to recognize behavior that's happening. Sometimes, oftentimes, students may not feel comfortable reporting something. It'll be staff that see it or administrators, and they have to determine how to address it, whether it's a discipline under code of conduct or this heightened shared ancestry Title VI standard. I also want to spend a moment talking about where, based on my experience and Beth's experience in investigating these kinds of cases, where we see this type of behavior frequently occur. Kids can be sneaky, right? They're not going to usually harass another student in front of a teacher in plain view. So we see a lot of these incidents when classes are changing in the hallways, at lunch, at recess, on the bus, sometimes, after school at an extracurricular activity. We certainly see social media activity, whether it's, as well as text messages, but, whether it's through Snapchat, just Instagram messaging, whatever it may be. So the short answer is it can occur anywhere. But the lesson or the takeaway is just because it's not happening in plain view doesn't mean that it's not happening. At the post-secondary level, it can be the same places that we talk about with K through 12. However, sometimes we have seen incidents that can rise to the level of shared ancestry harassment within a classroom, right? So you're balancing that academic freedom and First Amendment issues sometimes with where does it cross a line and veer into a Title VI problem. Certainly, we see it at protest, which also requires a careful balance with First Amendment rights and protections. But there is often a line where those First Amendment protections, that line is crossed and it becomes something that's more of a harassing behavior. So, all of these cases always turn on a case by case analysis. Sometimes you can have the same set of facts, but they occur at two different times and can lead to two different outcomes depending on the context. Next slide, please. Okay, so now we know about Title VI, and we know about the types of conduct that might rise to the level of shared ancestry harassment. The next thing that's really important for us to understand is, when does conduct that's based on shared ancestry rise to the level of unlawful harassment or discrimination? And when does a school become liable for that harassment? Or said another way, how does a school avoid liability? So, if you've done this kind of work in the past or done it for a while, you know that traditionally OCR used a different standard than the courts did for evaluating or analyzing cases involving Title VI harassment issues. And all of that changed on May 22nd, 2025, when OCR, in conjunction with HHS, released a decision letter involving Columbia University. So prior to May 22nd, the first thing we would look for is, did a hostile environment exist? Meaning, was there unwelcome conduct that subjectively and objectively one would find offensive, and it was so severe or pervasive that it limited a student's ability to access the education program or activity of the school? If that occurred, we then would look to see, did the school have actual or constructive notice of that conduct? Meaning, did they know about it or should they have known about it? If there was all these rumors going around about something that happened, a school couldn't just say, well, nobody filed a complaint. If a reasonable person would have known that that harassing conduct was occurring. And then third, once we had the harassing conduct, once we knew the recipient knew about it, we would look to see if a recipient took prompt and effective action that would end the harassment, eliminate the hostile environment and its effects, and reasonably prevent it from reoccurring. In the Columbia letter, OCR adopted the standard that courts use in deciding these cases, and that really changed the analysis of the facts. So now for the first prong, and I'm over on the slide on the left-hand side, we still look to see if there's a hostile environment that existed, though it's defined slightly differently. We now look to see whether individuals who were associated with the school were subject to severe or pervasive harassment that was motivated, at least in part, by their race, their color, their national origin, their shared ancestry. Generally, under both standards, one incident is not enough to get to that severe or pervasive standard. I said generally, though. It really does depend on the severity of the incident. So, for example, one incident of graffiti may not be enough. But one incident, if you have a student who's been physically assaulted because of their shared ancestry, that would arguably be more severe than that one graffiti incident. And that may be enough to get you over the hurdle for to find that there's a hostile environment. Like I said, the most important thing to keep in mind, these are case by case example of situations for you have to analyze. So every time it happens, you're sort of starting from scratch, thinking about how you're going to make these determinations. The second thing, now that we've moved over to the court standard as of May 22nd, is in order to be liable, the school has to have actual notice. So it's not enough that they should have known. We're really looking that somebody in the school knew what happened. Doesn't necessarily mean that a student has to go and fill out a complaint form and say, I was discriminated against on the basis of my shared ancestry. But the facts have to be known to the school in order to trigger their obligation to take action under Title VI. Third, the school has to have the ability to exercise substantial control over the harassers. This is usually pretty simple in the K through 12 environment because the school's going to have control over their students, over their teachers, over their administrators. It's often not that difficult in a college or university setting, but it can become complicated, especially if we're talking about issues that arise during protests. So often we've seen that students will protest, but they will be joined by non-students. So, for example, Beth and I are located outside of Philadelphia. There was recently, towards the end of the spring semester, a school in this area where there was a protest or a sit-in on campus. Areas of campus were being blocked, entrances to buildings, those type of things. The police were called in order to move the protesters so people could gain access to the campus spaces. But in reading about the police when they came and arrests were made, of all the people who were arrested, only one of them was actually a student of that school. So you can see where you might, if you're in the college and university or post-secondary setting, you really need to parse out who did the school have control over at the particular time the incident took place. The fourth prong, and this is the biggest change from the prior standard, is if you look on the right, we used to look to see if the school took specific actions in response to an incident or a hostile environment, right? We look to see did they take action to end the harassment, to remedy its effects, to prevent it from reoccurring again. The standard for establishing liability now is what we call the deliberate indifference standard. And this is arguably a much lower bar for schools to have to show. There's not a uniform definition of what deliberate indifference means, but generally speaking, if we go through all the cases and we were to put together an explanation, we would say we are looking to see was the school's response clearly unreasonable in light of known circumstances. And from what we've seen in cases that look at the deliberate or the facts under the deliberate indifference standard, that bar just is not as high as it was under the previous standard. So, for example, in the Eastern District of Pennsylvania, there was recently a lawsuit against Haverford College. And in that complaint, there's a number of examples of alleged shared ancestry harassment that took place. One of which was an incoming freshman who was part of a group chat of incoming freshmen. And because of comments that were made during that group chat, this particular freshman decided not to matriculate into the college. That was one of the examples the plaintiffs provided in support of their complaint. The judge in that case, though, found that the college did not act with deliberate indifference because once the student notified the college that they were not going to matriculate, a dean called the student and said, we heard you're not going to come. We heard why. We wanted to let you know you can file a complaint against that. The student decided not to file the complaint and that they were not going to enroll. And here the court said that was enough to show that the college did not act with deliberate indifference because somebody did call the student, let them know that they had an option to file a complaint if they wanted to. There, the college wasn't obligated under this court decision to look into what had happened, to take action if it was warranted against whatever was said in that group chat. So we really are working with a lesser burden now for schools. Next slide, please. So, what does a school need to do, or what should they do in order to show that they're not deliberately indifferent when an incident arises? Likewise, if you're a victim of shared ancestry harassment, what can you expect from your school as a response? So, the short answer is Title VI doesn't specify the steps that a school has to take in response to conduct or allegations of shared ancestry harassment. But we can look to previous OCR decisions or court decisions for guidance and best practices. Something else to keep in mind, this deliberate indifference standard is really the floor. It's not saying that you can't do more. And we would recommend as a best practice that you do what you, as much as you can, to address the incident, keeping in mind those steps of the previous standards about stopping the harassment, taking action to prevent its reoccurrence, remedying the effects on the victim of the harassment in the first place. At the end of the day, you have a school to run, and we think about those early points that I made about the effect that this type of conduct can have on students, can have on staff, can have on your school environment. So the first thing we would expect to see once an incident arises is that the school's going to interview the complainant, interview the respondent or the accused student to the extent that there is an identified respondent, as well as any witnesses. And that interview should really focus on the who, what, where, when, why, and how about the incident and follow up on what you learn, right? So if Beth makes a complaint and in interviewing Beth, she says, well, Amy was there when it happened, then you're going to want to reach out to Amy and talk to Amy. Or if Beth makes the complaint and says, this particular respondent has done the same thing to 5 other people, we'd recommend trying to talk to those 5 other people to get a sense for what is happening here. It's also vitally important that you document your interviews and your efforts for future use. It's possible that an OCR complaint or a lawsuit will come at some point in the future, and you need to be able to show that you weren't deliberately indifferent, that you did take action. And the best way to do that is through documenting all the steps along the way. Make sure you collect evidence from anywhere it may exist. Pictures are very important, screenshots of social media posts, those kinds of things. You'll want to review relevant recordings. We always recommend, if there is video, to get that video, back up that video, and save it. Often school video, bus video will kind of run on a loop and re-record after a relatively short period of time. So it's very important to preserve that early. Same thing with social media posts, text message exchanges. If you have swipe card records of when students, swiped into a building or swiped into a classroom, those sorts of things, to get all of that early and just preserve it. Once you've gathered all of your facts, you're going to need to make a determination about whether a hostile environment existed, right? Through your investigation, did you find that this conduct was severe or pervasive that requires a response under Title VI? You might find that it doesn't require a response under Title VI, but it may be violated another provision of your code of conduct, in which case you should feel free to discipline that way. Maybe it was inappropriate language. Maybe it was something else that violates the code of conduct, but didn't rise to the level of Title VI harassment. You could still take action for that. And finally, notify both parties of the outcome of the complaint. If there is any appeal rights based on your school's policy, those sorts of things, right? Students need to know what happened to the complaint after they reported it. One other thing I'll point out very quickly is that sometimes students and even parents are reluctant to report They're afraid of retaliation. They're afraid of making noise. I just want to point out that Title VI also has a retaliation provision. So if somebody makes a report of alleged Title VI harassment, it's imperative that retaliatory actions aren't taken against them. And if they are, or if they report there was retaliation, that is investigated as well. So with that, I'm going to turn it over to Beth.
Good afternoon, everyone. So now that Amy has discussed with you what the appropriate legal standard is to apply to these complaints and the importance of conducting an investigation and making a determination, I want to talk about what's next. So you've collected your evidence, you've done your interviews, you've made a determination, and you have determined that the incident that is the subject of the complaint has created a hostile environment. What's the next steps? On the screen in front of you are some of the best practices that Amy and I have identified through our work in negotiating resolution agreements with schools that we investigated for shared ancestry, harassment, and discrimination. Now, remember, Amy talked about this deliberate indifference standards. So what we're going to talk about right now are some of the steps that you can take to show to OCR, to show to a court, to show to any other administrative agency that you haven't been deliberately indifferent in the face of shared ancestry, harassment, or discrimination. These are all provisions that Amy and I have included in resolution agreements, but like Amy said, you are not limited to these provisions. You can certainly take other steps that you see fit in a particular case. And as you will see in the case materials that we provided several resolution agreements. The provisions in those agreements, they do look similar, but they're not identical for every case. And that's because the facts of each case are really unique, which requires a unique response to those facts. So I'm going to talk about some best practices, but again, you don't have to implement all, or you can implement all and some others as well. So I'm going to dive right in. The first best practice that I want to talk about is discipline, but I want to add two caveats to that best practice. First, in the work that Amy and I have done, not just in the shared ancestry space, but for all complaints of harassment, we have seen on a number of occasions that in response to a hostile environment, the natural step that a school will take is to discipline the respondent or the offending parties, which is a good first step. However, what we often also see is that that's the last step for a lot of schools. And in our experience in working these cases for decades, discipline alone is rarely sufficient to end a hostile environment. So while it is a good first step, it's really important to think about other steps that you need to take to remedy that hostile environment. The other caveat that I want to add is that there's a threshold matter of coding your incidents correctly. So I'm going to talk about a case later on where students were clearly engaging in anti-Semitic behavior, and the school coded the disciplinary sanctions as inappropriate behavior rather than as harassment. The sanctions for inappropriate behavior were much less severe than the sanctions would have been had they been coded as harassment. So while discipline is a really important best practice, before you get to meting out your discipline, you must make sure that you're coding these incidents properly so that the disciplinary sanctions you impose match the offense. The next best practice is no contact order, safety plan, separation in housing, dining, work, etc. The only caveat that I will add to that is you can implement a no contact order or a safety plan at any point during the investigation. But if you're going to take a step that places a burden on the respondent, like moving them out of their housing or moving them out of their work schedule, it's really important first to make a determination that that respondent has engaged in a hostile environment. The next best practice is a message from the president or the superintendent condemning the incident or the behavior. It seems simple enough, but this is actually one of the most well-received steps that a school can take by the community. The next best practice is actually one of my favorites, training. The training should address various groups. So first, training for students, so they understand what shared ancestry harassment looks like, so they understand what the consequences are for engaging in that kind of behavior. So they understand what the school's policies and procedures are under Title VI, and they understand where and how to report this kind of conduct. The next is training for your staff. So they also understand what shared ancestry harassment looks like. So they understand what the school's policies and procedures are, and what are the school's obligations for responding to Title VI incidents. And last, but really important, is training for your investigators and your decision makers, so they too have a firm understanding of what constitutes shared ancestry harassment and discrimination. They understand how to do a fulsome investigation like the one that Amy just described. They understand that they need to make a determination and notify the parties. They understand the appropriate legal standard to apply, severe or pervasive, objectively offensive, and they understand what their obligations are to respond to a hostile environment under Title VI. The next best practice is education for the respondent. We see this take a variety of forms, most often asking the respondent to write an essay on Title VI shared ancestry, write an apology note to the victim or the victims, or engage in very specific targeted Title VI shared ancestry training and the like. The next best practice is my favorite. It's a climate survey. This is where you're going to distribute some kind of questionnaire to your students and your staff, asking about generally the climate at school. The questions we would expect to see is to ask them, are they familiar with Title VI? Are they familiar with the school's policies and procedures addressing Title VI? Have they experienced Title VI shared ancestry harassment? Do they know somebody who's experienced it? Where did it occur? Who did it? Did they report it to the school? If not, why not? If they did report it to the school, were they satisfied with the school's response? You can do this kind of questionnaire any way that you want. Traditionally, schools do this through a questionnaire that's sent out through email, but you don't have to do it that way. You can do focus groups, you can do interviews, whatever method you choose. It's really important information that's going to give you a bird's eye level view of the culture at your school and of the areas that are problematic. And this information is going to especially inform the individual at your school who is tasked with coordinating responses to Title VI complaints to have information so that they can act proactively rather than always reactively to complaints. Meaning they will have information showing what are the areas of concern at their school, and they can develop outreach, education, other kind of preventive measures to tackle this proactively rather than waiting to receive a complaint. The next best practice is some kind of individual remedy for the victim, and not just the person who's filed the complaint. What we often see when you conduct an investigation is that you'll learn that there's more than one victim beyond just the person who filed the complaint. So for any victim that you've identified in your investigation, you should be offering some kind of individual remedy to that individual. Typically, that's counseling, reimbursement for past counseling, academic support, reaching out to a student's professors to coordinate extensions for assignments, tuition, academic reimbursement, and the like. The last best practice is to take a close look at your policies and procedures. Make sure that they adequately address Title VI shared ancestry harassment. Do they describe what Title VI shared ancestry harassment look like? Do they describe the sanctions available for engaging in this kind of conduct? Do they explain what steps the school will take to respond to Title VI complaints and the like? Now, before I move on to the next slide, I just want to make a few points that Amy touched on lightly as well. First, there are going to be incidents, particularly in the shared ancestry space, where free speech is at play in an incident. And this is an area where we have noticed a lot of problems in terms of the way that the school responds. Meaning, what we often see is when there's an incident that involves free speech, oftentimes the schools won't touch the incident, they won't investigate, they won't resolve, they won't make a determination because it's free speech. And that's not the appropriate response. There's one limitation when there's an incident that involves free speech. That limitation is that you cannot discipline the respondent. But as you can see from the slide, there are a myriad of other responses that you can take in the face of an incident that also invokes free speech. You have an obligation as a school, even when there's free speech, to determine whether that free speech incident created a hostile environment at the same time, and if so, take steps to address that hostile environment, the only limitation being one of those steps cannot be discipline against the respondent. The other thing that I wanted to mention that Amy touched on as well is that even if an incident doesn't rise to the level of a Title VI hostile environment, there may be other provisions of your student code of conduct that you should pursue. So for example, in an entire year, your school had one incident of graffiti. That's probably not going to be sufficiently severe, probably not going to be sufficiently pervasive, but you do have a provision of your code of conduct that addresses vandalism, and you should pursue that vandalism and charges for it under the appropriate code of conduct provision. The last thing that I wanted to mention is that a lot of these incidents also involve law enforcement. And oftentimes law enforcement will ask you to pause your Title VI investigation while they complete their critical fact gathering. And that's okay. You can pause your investigation, but your investigation pause should not be inordinately delayed or indefinitely paused. And you should not rely upon the police determination for your Title VI determination. Meaning, even when the police is involved, even when the police dismisses a complaint, you still have an obligation as a school to conduct your own independent Title VI investigation and resolution. The reason being that the legal standard of proof for a crime is very, very high. The legal standard of proof for a Title VI violation is much, much lower. You should not be applying this really high legal standard to the Title VI realm. You can use the evidence that the police gathered for your fact gathering, but you should not use their determination as a substitute for your Title VI determination. Okay, moving right along, I'm going to delve into some case reviews. The first three are cases that Amy and I helped to investigate and resolve while we were at OCR. The last one that Amy had already mentioned is the first of its kind coming out of OCR, a violation letter addressing shared ancestry harassment. So the first case I want to talk about is the Red Clay Consolidated School District. This is a K-12 public school district. The basis for the complaint was an incident where 3 students created a paper airplane with writing in red ink that stated "Blood of the Jews," with red ink splattered onto the airplane to mimic blood, and there were several swastikas drawn onto the plane as well. One of the students stood up in front of an entire classroom of students, threw the paper airplane at a Jewish student. It hit her leg and it fell onto the floor. The incident was captured on video recording, which was provided to OCR, which OCR reviewed as part of its investigation. But also, once the incident was brought to the complainant's attention, she asked the school to go back and take a look at a longer portion of the recording to see if anything occurred before or after the paper airplane incident. And in reviewing that video footage, the school discovered that there was in fact another incident that occurred shortly after the paper airplane incident, in which the same 3 students stood up and did a Heil Hitler salute directed towards the Jewish student. As Amy mentioned, by the time this incident was discovered and by the time OCR initiated our investigation, that recording was gone and we were unable to review it. The investigation that OCR conducted also revealed that there were repeated incidents of swastika vandalism, several of them directed towards the Jewish student herself and others just more generally throughout the school building. In response to the incidents, several of the offending students were disciplined. The victim met with the school counselor. The school separated the students. At some point, some of the offending students were removed from the victim's classroom. The school implemented a safety plan, a daily check-in for the respondent, and the school also held class assemblies on behavior and bullying generally. OCR identified some concerns in the school's response to the incidents. First, several of the incidents were not documented and provided to OCR during OCR's investigation. So OCR asked for all documentation of the school's investigation and resolution of shared ancestry complaints within a specific time frame. The district gave some, but not all of the documentation because they simply didn't have it. OCR obtained that documentation from other sources. And so this goes back to what Amy said earlier, the importance of documenting your investigations and your determinations so that when OCR or a court or another administrative agency is looking at your school and how it responds to shared ancestry complaints, you can provide documentation showing that you were not deliberately indifferent in the face of these incidents. Another concern that OCR identified is that the offending students were disciplined for some, but not all of the incidents. So for example, the 3 students who threw the paper airplane, they were disciplined for that incident, but they were not disciplined for the High Hitler Salute incident. Also, as I mentioned earlier, for almost all of the incidents, they were miscoded as inappropriate behavior. So the disciplinary sanctions didn't match the offense, but also it impeded the school's ability to see the sum total of all of the incidents in the aggregate to see whether or not there really was a pervasive environment of harassment on the basis of shared ancestry, because they weren't coding the incidents properly. Also, the school implemented a safety plan, but that plan wasn't implemented until about 2 months after the behavior started. And even when it was implemented, it wasn't always enforced. So the respondent violated that safety plan on a number of occasions, creating a very uncomfortable environment for the victim. Last, OCR reviewed the discipline records for the students that were engaging in this behavior and observed that these were not isolated incidents, that these students had been engaging in harassing behavior on all bases, racial harassment, sexual harassment, shared ancestry harassment, for over a year. And so clearly the steps that the school was taking to address these students is not effective. The remedies that OCR negotiated through the resolution agreement are many of the same that we discussed in the prior slide. Counseling and reimbursement for counseling for the victim. OCR asked that the school publish an anti-harassment statement on its website and also notify the community through email of that anti-harassment statement. OCR asked the school to revise their policies and procedures and conduct Title VI training for staff and students and distribute a climate survey. Also here, because OCR identified concerns with their record-keeping practices, meaning they weren't sufficiently documenting their investigation and resolution of incidents, another provision in the agreement was to ask the district to develop some kind of record-keeping process or procedure and provide documentation of its investigation and resolution of complaints under that procedure for a 2-year period moving forward. Okay, the next case that I want to discuss is Muhlenberg College, which is a post-secondary case. The basis for this complaint was a professor's conduct in the classroom and on social media following October 7th. In total, there were 8 complaints that were filed against this professor by both students and staff over about a 6-month period, alleging shared ancestry harassment through her conduct in the classroom and on social media. So on one incident, she took a picture of a display on campus that was developed by Hillel. She posted it on her social media account and made derogatory statements about the students who made the display. In another, she made a repost to her social media stating that Zionists should be shamed and not welcomed into your spaces. The evidence also showed that the professor and her partner engaged directly with students on her social media in a derogatory manner. During OCR's investigation, OCR also reviewed 25 other reports of shared ancestry discrimination and harassment, including swastika vandalism on student doors, social media postings, chalkings on campus, and tearing down posters of hostages on student doors. The investigation did reveal that college administrators met several times with the professor to discuss her conduct, but OCR nonetheless identified some concerns. First, it appears that they considered each report in isolation instead of looking at all of the complaints together to assess whether the conduct was sufficiently pervasive to have created a hostile environment, even if one incident alone was not sufficiently severe. So remember, the standard is severe or pervasive. So even if an incident is not severe enough alone, if you look at the aggregate of the complaints, you might start to see a pattern of pervasive harassment. Also, OCR identified concern in that the college did make a determination about the professor's conduct and whether it created a hostile environment, but only in 2 of the 8 complaints that were filed against her. And in the 2 complaints where the college made that determination, it used the wrong legal standard. So to determine whether or not the professor had created a hostile environment, the college looked at whether or not she was directly targeting students. That's not part of the legal standard that Amy described earlier. Also, the emails did reflect that college staff acknowledged and recognized that the professor's conduct was interfering with students' ability to access the educational environment. But other than speaking with the professor on a few occasions, there really wasn't much evidence to show that the college addressed that impeded educational environment. So the resolution agreement is also in the course materials that we provided, includes a lot of the same provisions we talked about, Title VI training, climate survey, and in this particular case, OCR asked that the college provide documentation of their investigation and determination for all of the remaining complaints made against the professor and all of the other incidents that were reported to the college in a specific time frame. You will also see that this agreement is a little smaller than some of the other agreements, and that's because OCR did recognize that the college took many important steps. So, for example, the president emailed the college community to address shared ancestry harassment. Administrators provided direct support and check-ins with the Muslim, Palestinian, and Jewish students. The college created a brochure about doxing and distributed it to the college campus. They also distributed a 5-minute video outlining the college's Title VI process, and they conducted training for staff and students. You'll also notice in this particular resolution agreement, OCR did not ask the college to revise their policies and procedures, and that's because OCR determined that those policies and procedures were sufficient to address Title VI shared ancestry harassment. I am so sorry for speaking so quickly. I'm trying to get through all this material. Okay, the next one is Lafayette College. It's another post-secondary case. The basis for this complaint was a protest that occurred on campus on October 25th, 2023. Administrators knew about the protest, so they attended it to observe. And while they were observing, they saw a student holding a poster that read "From the River to the Sea." Following the protest, they identified the student, and the college chaplain spoke to the student on a number of occasions to explain to the student why that phrase could be offensive to Jewish students. The college president also issued a statement shortly after the protest saying basically the same. During OCR's investigation, OCR also looked at 11 other complaints of shared ancestry discrimination and harassment, those mostly focused on social media postings. OCR did identify concerns, but interestingly here, OCR did not identify a concern with the protest or how the college responded to the student that was holding the poster. So, for example, this is a good example of a college addressing a potentially hostile environment, even where free speech was involved. So the student held up a poster that invokes free speech. The student was not disciplined, but the college chaplain just did speak to the student on a number of occasions, and the college president did issue a statement to the college community addressing it. The concern that OCR identified was actually in the way that the college responded to, or in fact did not respond to, private social media postings. The college had a categorical policy to not address allegations of harassment on private social media or off-campus conduct, which is a misunderstanding of its obligations under Title VI. So schools must assess whether conduct that occurs off-campus or on private social media creates a hostile environment that spills over into the college community. You'll see that the remedies in the resolution agreement here are much like the Muhlenberg College resolution agreement. It's a smaller agreement, and OCR also acknowledged that the college took positive steps like the email from the college president, increased security around religious spaces. The president and the chaplain met with Hillel on a number of occasions, and they had meetings with the student who held the poster. So the remedies here were a revision of policies and procedures, investigator training, staff and student training, and file reviews. Okay, so the last case I want to discuss is Columbia University. Amy and I had no involvement in this case, so what I'm going to discuss is really just based on our review of the letter and our knowledge of OCR processes. This is the first violation letter on the basis of shared ancestry coming out of OCR. It was a joint letter from HHS OCR and Ed OCR on May 22nd, 2025, following a 3-month investigation. Since the preparation of this PowerPoint, there's actually been another letter issued against Harvard University that was not jointly issued. That was issued solely by HHS OCR, and that was published on June 30th, 2025. That letter is very, very similar to the Columbia University letter. The most important takeaway from this letter is, as Amy discussed, a significant shift in the legal standard that's applied in Title VI hostile environment cases. So it used to be prompt and effective. Now it's the deliberate indifference standard, and that standard is the same that's used by the courts. Interestingly enough, it's also the same standard that is written into the Title IX regulation for Title IX sexual harassment. So as Amy described earlier, there are 5 prongs to assess whether or not a school has been deliberately indifferent in the face of shared ancestry harassment or discrimination. The Columbia letter goes into those 5 prongs, and I'm going to briefly discuss the evidence that OCR relied upon to meet each of those 5 prongs. So the first prong that Amy discussed, you have to establish that there was a hostile environment. Was the conduct objectively offensive and severe or pervasive? Here, OCR concluded that it was, and the evidence that they cited to was unauthorized protests with threatening and intimidating rhetoric, protesters blocking access, disrupting a class about the history of Israel, and using language that was berating to Jewish students, reports of physical harm to Jewish students, acts of anti-Semitic vandalism, harassing speech like globalize the Intifada, death to the Zionist state, Hamas, we love you, and burn Tel Aviv to the ground. So first prong, hostile environment established through severe and pervasive conduct. Second prong is to establish that the education environment has been impeded. OCR cited evidence showing that the educational environment was impeded here through students' inability to enter classrooms, to enter school buildings, to walk across campus because there were barricades, protests, and encampments, and because students had occupied certain buildings. Third prong is actual knowledge. And here OCR cited to evidence that the university had actual knowledge of the harassing conduct. It was established through complaints filed with the university, press reports, lawsuits, congressional inquiries, and the like. Fourth prong, substantial control. OCR concluded that the university had substantial control over the conduct because much of the conduct occurred on campus, and also because the university has control through its standards of discipline, which prohibit discrimination and harassment. Fifth prong, most important, is you have to establish that in the face of this hostile environment, the university was deliberately indifferent. And here, OCR focused on 3 areas to show deliberate indifference. First area is in the university's reporting process and procedures. So even when students reported discrimination concerns, they were dismissed, downplayed, or not addressed. So in many cases, the university just didn't investigate complaints that were brought to its attention, or the university minimized student concerns. And in some cases, students were diverted to counseling rather than have their complaints investigated. And where the university did conduct an investigation, there was little documentation to show that the university had actually made a determination as to whether or not that incident created a hostile environment. Second area that OCR found deliberate indifference was in its response to repeated vandalism. So the evidence showed that there were repeated incidents of anti-Semitic graffiti, and that college staff had complained on a number of occasions about it. And the university's response was just to have staff clean it up, rather than conduct an investigation, try to figure out who was engaging in this vandalism and address it through disciplinary sanctions. The third area where OCR found deliberate indifference was in the university's failure to control harassment and discrimination against Jewish students during protests specifically, in particular, by failing to consistently enforce the university's time, place, and manner restrictions on protests. And even when they did respond, the response was often delayed, and OCR also made a note that the judicial process for imposing disciplinary sanctions for violating those restrictions were also delayed. Okay, that was a lot of information. Amy touched on this very briefly. As you all probably know, OCR has been impacted by some of the reductions in force. 7 of the 12 offices were closed. So we've seen some reporting in the press pondering, why is all of this important if there's reduced OCR enforcement? Aside from the obvious, which is that schools should be safe and inclusive for all students, as we've discussed here today, the government is still very actively investigating these cases. We now have 2 violation letters against Columbia University and Harvard University. And unlike prior administrations, this administration actually revoked funding even before the violation letters came out. So the stakes are much higher now. And OCR is still opening complaints on the basis of shared ancestry. It has several open directed investigations. Just last week, OCR announced in a press release an investigation against George Mason University for shared ancestry harassment and discrimination. In addition to that, there are still applicable state and civil rights laws. So for example, in Pennsylvania, we have the Pennsylvania Human Relations Commission, which has enforcement capability over Title VI and applicable state laws. And several state departments of education also have enforcement capability over Title VI and similar state laws. And as we've all seen in the press, there have been a myriad of state and federal lawsuits, and the stakes are higher there because courts can issue punitive damages where OCR traditionally does not. And then last but not least, there have been a number of high-profile accusations in the press, and the last thing that a school wants is for its reputation to be tarnished in the press. This last slide just provides resources where schools can ask information or students can get recourse. I'm not going to dive into it because we've addressed most of it already. Last slide is just my and Amy's contact information in case you want to follow up with questions or concerns after this presentation. And with that, we don't have time, but Amy and I are willing to stay on if there are questions.
All righty. Well, it doesn't look like we actually have any current questions right now, but once again, of course, our members are encouraged to reach out to you if you have any questions, or you can always, if you somehow miss the contact details, you can always reach out to us and we can forward that information over to Beth and Amy. I have to say thank you so much, Amy and Beth, for today's presentation, and thank you so much to our audience for joining us this afternoon. Have a great day, everybody.
Thank you.
Thank you.
Thanks, everyone.